Crystal Rogers was first reported missing July 4th weekend 2015. This summer will mark a decade since her disappearance and her family's chance at finally finding justice. Thanks for joining us on WHAS 11 Plus. I'm Shay McAllister. The first of two trials in her case start at the end of May. So today we want to bring in our legal expert, Nick Mudd with Mudd Legal Group, for more on what to expect on these fast approaching trials. Thanks so much for coming on, Nick.
Thanks for having me.
Appreciate you. Yeah. First, if you could just remind everybody who you are and where you are an expert.
I don't know if I'm an expert, but my name is Nick Mudd. I'm a local attorney here in Louisville, Kentucky. Practice primarily here in Jefferson County in state and federal court. Do a lot in Oldham County, Bullitt County, and surrounding counties, sometimes farther out in the state, depending on the case. I was a prosecutor for about 6 years with the Common Attorney's Office here, prosecuted mostly violent offenses, a lot of murders, robberies, assaults, things of that nature. I've been in private practice now for about 9 years, and my office is located here in Louisville, down in 6th and Main.
So let's start with this first trial. It's Steve Lawson, set to begin at the end of May. The most recent development in his case was the judge saying no to additional DNA testing on hair that was found in Crystal Rogers' car.
What has to be determined is, what will we gain from testing these hairs versus these victims' rights to go to trial?
The prosecutor was the one who brought it to our attention. The prosecutor's the one who said, I want to take a closer look at these hairs. Well, then the prosecutor kind of backed off and said, never mind, they don't match either suspect. We know that, so we don't need to go any further. Defense attorney saying, hold on a second, we think that there might be another suspect here.
None of us are qualified to stipulate as to who hairs belong to or who they don't belong to.
And the judge saying no, ultimately saying, we think it's a delay tactic. What do you make of this?
I think the judge looked at it, and what the defense wanted to do is have the potential DNA that could be pulled. We don't know if it could be or not, but could be tested against what's called a CODIS database. And that's a database. If someone's convicted of a felony, the probation and parole office generally does, when they're first convicted, what's called a buccal swab of their mouth. Their DNA is then entered in a system, and it's kind of ran against any sort of DNA that's checked to be tested. So the ideal was from the defense is to say, hey, we want to test these hairs. We know it's not, our client, or it's not Stephen Lawson per se here, what we're talking about. We'll run it, and if it's somebody else, and say, hey, well, this guy lived in that area, and he's been convicted of another murder and another disappearance of someone, et cetera, et cetera.
Mm-hmm.
That was, I think, the tactic on their part from the defense for Stephen Lawson. That being said, I think the judge looked at it as, look, feel free to argue that. And if you want to argue that, go ahead. If you look at the judge's order, Judge Sims's order is pretty clear that, hey, I'm not going to waste time on this case and allow this to be delayed any longer, because DNA testing, it's not like what's the CSI show?
Right.
People think it's done in a matter of an hour and that's it, and the next day we know the results. It's not that simple. It is a long process. I'm familiar with the process, but I don't, I'm not in the lab on the ground.
Sure.
I just know it takes a while. I mean, I've had DNA take up to, I think I had one case, it took 18 months for us to get results.
Wow.
And there's a lot more complications with that, but it took,
Wow.
over a year and a half. And so, I think the judge looked at it here and said, look, I'm going to let you infer to the jury that because it's not your client on there that we know, you can argue that it is an alternate perp, but we're not going to waste any more time testing this and drawing this out any longer, which, as I said, could take up to 18 months.
Do you think the defense could have been looking for a delay tactic here?
It could be. It depends on, the lawyer's schedules a lot of times.
Sure.
And what other trials they got going on, what they have going on in their lives. Certainly, this case, there is an enormous amount of discovery. Mm-hmm. Discovery is the evidence in the case, as you know, we've talked about before, is that's kind of the generic term that lawyers use in court. And that comes from everything from eyewitness testimony, cell phone dumps, DNA, blood, fingerprints, any of that is considered discovery. And that's what, when we say that term, that's what we're referring to.
So ultimately, judge says no, we're going to trial. Trial is set for May 27th, day after Memorial Day. So let's talk a little bit about what that might look like. Mm-hmm. First of all, jury selection. They've moved it to a different county, Warren County, Bowling Green area,
right,
to get a fair and impartial jury. Let's dive into this a little bit. How many people do you imagine they're going to call for something like
So
this?
it depends. Generally in Jefferson County, when we have homicide cases, the judges here generally bring up about 65 people. That's normally, when you start. And, through that process, it's whittled down to, it's supposed to be 12 that sit on a jury. Most judges, especially in a case like this, will sit 2 alternates. And what that means is you don't know you're an alternate. You may sit through the whole case. You may sit through day, month, 2 months, however long it takes. And after the last closing argument is over and the judge reads the jury instructions, the judge really draws 2 names out of a hat of the 14 and says, thank you for your service. You've been chosen as an alternate. You're dismissed from this jury. Wow. So, which some jurors can get very upset about.
So what kind of questions are they going to be asking during that initial interview phase of the jurors to find those 12 people?
It would not surprise me if Judge Sims says, please raise your hand if you've heard about this case, if you know anything about it, and then have them individually approach. The question's going to be how much knowledge juries have, how many have knowledge about it, and, have any of them been swayed? If people are watching things like this that you and I are doing right now, they probably shouldn't be on the jury because it could sway them, one way or the other. Not that you and I are trying to do that. You're just reporting the news. You're asking me questions. But certainly, when you get a jury, you want a jury that is fair and impartial. That really is what I call a blank slate, okay? And most people target that toward the defendant, but there are times when the prosecution may have done something that people don't like. They see something in the news like, well, I don't appreciate that. I don't like how that prosecutor acted or what he did here, or that tactic that would not normally be admissible in court. So people can really be prejudiced both ways, one way or the other.
Does just having heard of the Crystal Rogers case automatically disqualify you from sitting on this jury?
That's a great question. As a defense lawyer, if I'm on the defense, I'm going to argue that. Judge, this is, they've heard about it. They're already, they have something in mind. It doesn't though, Shay.
Okay.
Okay, it's you can't just say, well, people were supposed to cover their ears and not hear anything about it. This case is a national case. It's at the forefront of news right now, especially in criminal justice. So that alone does not disqualify. The question really is, have you formed any sort of opinions prior to the case starting, before you've heard any evidence? And if the answer to that is yes, then they're really not a fair and impartial juror.
How long do you think it's going to take to sit this jury? How many days of questioning would you imagine?
The normal process, though, in a non-death penalty seeking homicide case, the judge may ask some initial questions. He wants to make sure, A, everybody is a resident of that county, that everybody has a right to be there, meaning if they're a convicted felon, they can't serve. Okay, or they haven't been pardoned, or things like haven't had the record expunged, that they're qualified in the sense that they haven't served on another jury panel within a separate voir dire panel within the past 2 years, meaning, if it was a year ago and they were on a jury, generally it's supposed to be, you got to wait 2 years. I assume Judge Sims on his own will go through the media questions. Once that's done, the prosecution will get a chance to ask questions. And a lot of those are going to deal with bias and things like that, who may have worked as a police officer, corrections officer, who has police in their family. Do you think a police officer is more credible compared to a lay witness? And a whole host of those questions. At that time, once Mr. Young is finished with his questions, or any co-counsel, the attorneys, and here Stephen Lawson's attorneys will get to ask questions. Generally, those are more defendant-focused questions. And so those may be, what do you know about this case? What have you heard about it? Have you formed an opinion? Do you understand he's innocent as he sits here? He's innocent until proven guilty.
So it's almost your first chance to really talk to the jurors, to start planting your case.
It is.
Okay.
Now, some judges, especially in federal court, limit that a lot. Yeah. They do not like that in federal court, the indoctrination stuff. But state court, the rules are a little more loose, and we're dealing with state court case here. So the Kentucky rules allow the lawyers a chance to really ask a lot of questions, get a little folksy with the jury, make them laugh. I mean, you were going to be with these people for maybe a week, 2 weeks, a month. You don't want them to not like you. And I mean, that's just a fact. Some people don't like to hear that, but you want to be, they don't have to love you, but you don't want to be insulting to them. And you want them to listen to what you have to say. You want them to respect what you have to say. And you want them to know that you're prepared and you came to defend your client.
Is there any chance that they can't find 12 people here in this jury pool to sit on this jury?
That is possible. I think that, and it wouldn't be, hopefully they will, but it wouldn't be unsurprising. Given the amount of publicity the case has, and I think it has a statewide appeal as much as a nationwide appeal as well, it would not surprise me if, they had to go through a couple panels. Hopefully that doesn't happen, but it may take much more than 65 people to get a jury here.
Okay, so as you know, he did have an attorney, Ted Lavitt, early on in the case, and eventually said he wanted him off the case. He accused him of working with Brooks Houck's attorneys behind the scenes, and we really haven't heard anything more on that. Is there any chance that that comes up in trial and plays any role here?
I highly doubt it. It's just not going to be beneficial to Stephen Lawson's attorneys to argue that to the jury, because really that has no bearing on any facts of the case of whether somebody's guilty or innocent.
Okay.
Right? I know one of his attorneys, Darren Wolf, personally. Darren's a great lawyer. He's tried a bunch of cases. He's a friend of mine. We've done cases together. So, he is well-versed in the law, and he is a great lawyer, knows what he's doing. And I highly doubt that Mr. Wolf would use that as a tactic somehow to gain any sort of advantage. It just doesn't seem beneficial. That has more to do with maybe not liking your other attorney previously.
Sure.
That has nothing to do with whether or not you're guilty of the offense. And I think Judge Sims, if that came up somehow, he's going to shut that down.
Okay.
It would be a little different if they were using Brooks Houck to testify against Stephen Lawson. Clearly not happening here at all, or should it happen, but that would be a different story, but that's not what we have here. So I just don't think it's going to be an issue at all.
So Darren and Zach, the two new attorneys that were appointed in August, and they have been saying since August, since their very first time in court, there's no way we're going to be ready for this trial.
I don't want to come here today and basically put anybody in an illusion that this is just going to continue as originally planned.
Is that too short a time, 9 months, to prepare for a trial like this?
Every case is different, okay? But I will tell you, most homicide cases that I've had usually take, with me on the case, 1.5 to 3 years to get to trial. Normally there's a ton of evidence to review, which we have here. The stakes are very high. It is no longer just a tampering with evidence. It is conspiracy to commit murder as well. So the stakes are ultra high. It's not surprising, Mr. Wolf. I don't know the other attorney on there. I just know Mr. Wolf very well. But it doesn't surprise me that Mr. Wolf would request be continued again, just because of the fact I do know, given the serious nature of the case, there is a plethora of evidence to go through.
We literally just got appointed to this thing. So we've been given 2 terabytes of information, which clearly is more than most cases. And the investigation in this case is strung on for an extensive period of time.
And it's not like he's like me. He doesn't have just one case. He's still got to go to court in the morning be it for a traffic ticket or another homicide case or a domestic case, et cetera. I mean, it could be, he's got several other cases
It's not the only thing on his plate.
Correct. It's not like he could drop everything and just work 10 hours a day on that. I mean, that would not be sustainable for his practice. And so, it does feel a little quick, I will say, 9 months for a homicide, where we do know there was, tetrabytes of data, not gigabytes, tetrabytes of data, okay? I will say my whole practice fits on, with all the cases I have pending currently, fits on, I believe, 3 tetrabytes, and that is hundreds of cases, okay? So we're talking about one case with 2 tetrabytes here. So that gives you an idea of how much there is to review. So I do think 9 months is a little early. It's a lot early, to be honest with you. But again, I know Judge Sims wants to be efficient, wants to get this case done, doesn't want there to be any more delays.
Right.
And, the family deserves justice as much as the defendants deserve justice, to have a, fair, a quick and speedy trial. So.
Could there be a last-second push here in the days, the week leading up, where they say, we're going to file once again to continue this trial?
I will say there makes a judge nothing makes a judge more angry than filing a motion to continue at the 11th hour. I have done it. I will probably do it again. But there are times where, you know, you get that 2 weeks before trial and you really start prepping, you start writing out everything, and you get deep in and you find something and you say, oh my Lord, this has got to be tested, or I need an expert on this, or I didn't realize there was this much here on some other topic that you want to explore. So it is not uncommon. I mean, I've had homicides get continued 4 or 5 times from both sides, the prosecution and the defense, given the amount, just again, the 2 tetrabytes of data, the amount of discovery here. It would not surprise me if Stephen Lawson's attorneys file another motion to continue based on the fact that they may feel what's called ineffective. Doesn't mean they're not great lawyers, just means, Judge, there's so much here, we do not feel we can effectively prepare given that time constraint.
They've mentioned that. I think Darren has said himself, this will be ripe for appeal if we go forward with this trial, if there is a conviction because of ineffective counsel. Do you see that? If there is a conviction, that just this 9-month, this fast time period could play a part there in an appeal?
I think that, you know, appeals are tough. They're tough to win as from the defense side. But, you know, he has stated that on record. It's not something that's coming later. He has said, Judge, you know, I don't feel like I have enough time to get this trial ready. So I think if there is a conviction, it could play into appeal. Appeals, though, are like juries. You never know what's going to happen.
Let's say trial does get underway as planned here. They're able to sit the jury. Are we likely to hear how Crystal was killed during this trial, based on the charges and what you know about it?
I would say no, because we don't, you know, you and I know there's no body that's been recovered. We do not know what happened to her, and we don't know where her body is. We don't know, is there a murder weapon? You know, what was used, how it was used. We don't know, was this a suffocation, a strangulation, a shooting, a stabbing? We just don't know. And I think the prosecution is going to argue you don't need to know to convict someone. All you need to know is that Stephen Lawson conspired to murder Crystal Rogers with Mr. Howe.
So that might be as far as we get into the details of her death.
Unless there is something in discovery that we don't have a copy of it, you and me don't, to review the 2 tetrabytes, but unless there is something in there, I would think we would probably hear about it by now if there was, but we don't know. Trial is full of surprises, and you know, as we say in the legal world, you can prepare all you want, but trial happens. And when it's happening, there are things that you can't anticipate, and you have to be ready for anything.
Is there going to be anything the prosecutor does not say in this trial, knowing that Brooks Houck is up for trial just a few weeks later? Is there anything that he would want to hold back as to not give Brooks a leg up?
I doubt it. I mean, I think that I know Shane Young. He's a great prosecutor. He's an aggressive prosecutor. He's going to go full bore one way or the other. And so I highly doubt anything would be held back. That being said, I think there is a significant advantage to going second. If I could go second in every one of my co-defendant trials, I would feel like I'm on a much better footing. When you get to go second, 2 big things. Number one, you get to hear the prosecutor's theory on the case, right? Because the prosecutor doesn't have to disclose their theory of what happened, how it happened, why it happened, et cetera, really until they don't ever have to, but you hear it in opening statement.
Right.
So once you get the opening, you kind of know, but again, trial's happening, you're scrambling, so your preparation, you don't have time to prepare, you're in trial. I go second, I get a chance to hear that whole thing of what they've prepared, okay? Number 2, you get witness testimony under oath in front of a jury, sworn testimony. So if that person were to say something different later, you could impeach them and really accuse them of perjury.
So will Brooks' attorneys be in the courtroom listening to this?
I would say they would be every single day of it.
Using maybe what they hear there in their case.
Absolutely will be using.
Wow.
I guarantee they will be using.
Wow.
I mean, there are, you know, our job as attorneys is to pick things apart. It's what we do. Some people don't like that, but that's what we do. We try to poke holes in truth, and what's true still stands, right?
Right.
So I would say there will be ammo given to them to Brooks' attorneys for sure. Mr. Shoring and Mr. Butler will be sitting there listening, taking notes, and at the end of the day, probably asking for what's called like the official proceeding, the videos, and getting those transcribed, et cetera, to be prepared for, hey, you're going to call that witness again in my trial? I'm going to be prepared to cross-examine them and try to make them out to potentially be not credible.
So we've heard from people in communication with the prosecutor's team that he's anticipating about a week for this first trial. Does that seem realistic?
That's a good question. And the jury selections, what I'm curious how long that's going to take.
You think that could be the longest part?
That could be, it could be, yes. It doesn't sound like the proof's going to take that long, but again, we have 2 tetrabytes, so we don't know what's going to be used,
Sure.
right? So I don't know, but it seems a little quick given the case itself and given the length of the investigation. I assume I know Mr. Wolf, he likes to cross-examine on as many points as possible, which he's doing his job. I respect him for doing that. It's a good tactic. So I foresee it going longer than a week. I could be wrong, but I would say I certainly expect a couple weeks out of this one.
Wow. Okay. Obviously, we know a plea could come at any time here.
Anytime.
Most murder cases do end up with a plea.
Yeah.
What do you think? Does that happen here?
It could. It possibly might. I don't know. This case has so many different dynamics. You know, a lot of times you get cases and they want to what's called flip people. Hey, we want you to testify, or you know, we'll give you this deal, we'll probate you, we'll let you out of jail today if you testify against.
They've tried to do that.
I know.
They've tried to do that here, right?
I think though, a lot of my clients, I have been in front of, you get that jury, and as a defendant, you get to see the people that are going to be essentially judging your fate. And a lot of times people have a change of heart and say, hey, I don't like how this jury looks. And I've had clients ask me, what do you think? We'll pick a jury, and they'll say, what do you think of the jury? And there are times I've said, I think we're good. I like this jury. And there's other times I'll say, we didn't get anybody we wanted. They didn't strike the judge didn't strike the people we thought shouldn't be on here. And that could affect everything. I mean, it is
So it could be even the jury's seated, we could still have a plea.
Absolutely.
Wow.
You know, you never know.
Okay. Nick, thank you so much.
Yeah, thank you.
We appreciate
Yeah,
you,
it was
as
fun.
always. We have extensive coverage on the Crystal Rogers case on our website right now, including a full timeline of every major development since she was first reported missing a decade ago. You can see it right now on WHAS11.com.